So yesterday, after the jury was excused, remember it's a very short day, the parties stayed behind to have some initial conversation about juror instructions, right? The charging documents, if you will. And so let me kind of explain. I mean, some of you I know don't live here and you might have a hard time understanding how our legal system works. Believe me, I live here and I don't understand how our legal system works sometimes. But let me see if I can explain it to you the best I can. So the jury has to be given these instructions. So here's all the evidence. You're going to go back in this room. And when you come out, here's what the expectation is. And here's the things you're allowed to do. Here's the things you're not allowed to do. Here's the things you can consider. Here's the things you can't consider. It must be unanimous. You must all decide on one of these things. And typically it starts out with the harshest thing, first degree murder. Then it might go second degree murder. Then there might be other options as you go down the page. So technically what the jury should do is go to the first one and say, okay, is this it? And if this is it, we're done. But if this isn't it, then let's go to this one and decide if this one's it. And if it's not, then this one. So they kind of go through the list. The prosecution went first, and she did mention kind of these things that the judge must tell the jury. She wants them to have instructions on consciousness of guilt instruction, like was her behavior that of someone that knew she was guilty of a crime, the stipulation. So remember during the trial, they stipulated to some of the evidence in the chain of custody pieces. There were some in the evidence, there are some redactions, there are some corrections to call that out to the jury so they don't necessarily use that incorrectly during their deliberation. And then there were some prior statements that were either consistent or inconsistent, and being able to call that out to the jury to say, you know, sometimes a witness says something to the police and then their story might change a little bit when they get on the stand. And so they're going to provide instruction about how to kind of think through all of those items. When it comes to the charges, the prosecution wants this to be either first degree murder or second degree murder. But either way, they've said they want this kind of added verbiage that is the crime was both deliberate and premeditated and conducted with extreme atrocity and cruelty. And the words atrocity and cruelty have been something that have lingered through this case. That is exactly why they have treated Lindsay the way they did, is because they're trying to tell the jury that she used extreme atrocity and cruelty when she killed her children. Therefore, she deserves to be treated the same way. Have to decide if Lindsay is criminally responsible. So when it comes to that, they asked that any instruction regarding intoxication not be given to the jury. Because they don't believe that there's any evidence in the case that proved that Lindsay was essentially high on drugs, right? We know it's not alcohol intoxication. We know it's not illegal drugs. It's prescribed medications that we're talking about. But they're saying at the time the killings took place, she was on a very low dose, 10 or 20 milligrams of these two medications. And so it couldn't have been intoxication. Maybe intoxication happened earlier in November, December, when she was taking multiple drugs all at the same time. But on the day, at the moment of the killings, there wasn't any way she could have been intoxicated at that time. That's what they're arguing. I think Judge Sullivan is interested in putting in some type of intoxication language. So he's looking into the state OUI laws, because his question is, how do you measure intoxication in this case, right? Because when it's alcohol, you can say, if you reach this point, like point blah, 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 whatever, you're intoxicated. Anything below that, legally, you're not. And so there's a standard. But with prescription medications, that's a little bit harder, because it says right on the label, might cause drowsiness, might cause dizziness, might cause loss of appetite. So it says on the label, but how do you know when it's doing what it's supposed to do, or when it's to the point of overdoing what it's supposed to do? Like, how do you measure intoxication when it comes to this type of situation? So I think he's going to go search for some sort of legal standing to try and maybe put intoxication in, because that's what Reddington is arguing for. Reddington gets up there and he says, it's absolutely crazy not to put, he says, like, you'd have to be blind and like not watched a minute of this trial to think that there wasn't some sort of involuntary intoxication here. And maybe it wasn't on the day of the killings, but he says that all of those medications, all of those different prescriptions over time contributed to the state of mind that she was in when she killed her children. So, and then he's saying there's verifiable proof, right? She told people, she told doctors, she told family, she told people, I have brain fog. I have sleepiness. I have anxiety. Da, 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 da. She explained to them. She complained what the medicines were doing. And he says they continued to give her more SSRIs. They continued to change doses. They continued to do these things, which continually exacerbated the situation. When it comes to the language for not criminally responsible, he essentially defaulted to the judge. We can use the same instruction that's in the model jury instruction. He said that there was just previously a trial in that courtroom with Judge O'Shea where the same situation came up. There was a not criminally responsible charge in that case. He sounded comfortable using the same jury instruction that jury got. But then Reddington added a lesser included charge, asked to add the charge of involuntary manslaughter with a component of the impact of intoxication. So she would be essentially guilty of involuntary manslaughter due to intoxication, right? That's kind of what he's looking to put in as a lesser charge. Now, that might be a good alternative for the jury, right? If they don't want to do first degree murder, if they don't want to do second degree murder, some sort of involuntary manslaughter charge might be a feeling that they have done something to punish her, but respecting the fact that she was obviously under the influence of something that caused this to happen. I'll continue this conversation next week and we'll see what ends up going to the jury. In the meantime, let me just clarify for people who are questioning this. Yes, I do think that someone killing their kids is abhorrent. I do. This is a case about 3 dead children. I've not forgotten that fact. And I've said all along that I believe that Lindsay did kill her children. What's at question is why Lindsay killed her children. What was her mental state at the time? I've said repeatedly that this is about, is she going to go to prison or is she going to go to a hospital? I know a lot of people don't love the idea of a hospital because you think it's a get out of jail free card, but I promise you it's not. Go do some research on state mental facilities. Just please don't use the internet because I've been getting criticized for using AI. So get in your car and drive to no, you can't get in your car because gasoline also kills the earth. So get in your electric car or ride your bicycle to the library, look it up in an encyclopedia and learn a little bit about state mental facilities because they're not a pleasant place. I anticipate the defense will have their last few witnesses today and then the defense will rest.